Good morning, sir. Are you Dean Keith Barley? And Mr. Barley has two cases that he is currently on probation for, and motions to revoke probations have been filed in each of those. Cause number 18-28800, on probation for violation of a protective order, and also in 18-29063 on probation for violation of a protective order. Those are both deferred probations. Mr. Burbank has filed requests in both of those cases asking that I set bonds. Sometimes I do that without a hearing, but due to the nature of the underlying offenses as well as the new alleged offense, I wanted to come and hear from probation and the state as to what your position is with regard to any bond that I would set. Ms. Malfino?
Yes, ma'am. Judge, obviously I will defer to whatever Ms. Johnson thinks is appropriate. I do want to let the court know I did reach out to the complainant in the underlying offense. I've actually maintained contact with her just on a friendly basis since the original offense that I handled back in 2019, just to be able to assure the court that those issues do not involve that complainant, the issues that he's having now. There is no issue with the Hartley family, which I was glad to hear. Obviously, my concern is that there's been another assaultive offense. There's also been an allegation of a possession of a controlled substance. So 2 new offenses while on this bond, in addition to multiple violations, in addition to everything that Ms. Johnson has already made available to Mr. Barley. So I know that he's entitled to a bond as he is on deferred.
Maybe he is without certain findings. So that's why we're here. So just also for the record, Mr. Barley, and I know you know this, but I'm going to go through just so that we're all clear what the allegations are in that motion, and just that they're allegations, and obviously they have.
Prosecutor Ms. Mino confirms 2 fresh charges while already on probation. The judge reads the list: opiates, alcohol, and cocaine in his system, plus being out at 3:19 a.m. where he shouldn't have been. Each detail makes things worse. Barley's situation is crumbling fast.
Graham, looks like there was another urine sample that tested positive for alcohol in April of this year. Then it also alleges that you committed a new offense of possession of a controlled substance, May of this year, that you possessed crack cocaine, which is the same date as that offense, and that you were at another location other than your residence at approximately 3:19 a.m. on May 29th, the date of that offense of this year. So what do you have the status? I know the lab, we've had some issues with lab results. Is there any idea on that, Ms. Malfino?
I do not know, Judge. I would venture to guess that with it only being several weeks ago, we probably do not have anything. I'm happy to reach out to the agency and ask if they can expedite that through the lab and be prepared for a hearing whenever the court can.
And Ms. Johnson, thank you for being here. And so what is your thought, I guess, with regard to setting a bond? And if I did set a bond, what specific conditions do you think would be helpful?
I received his case. I became his officer in February of last year.
Okay.
And since then, I have put him in ISF cognitive. I have put him in JTDI. Prior, he's been an MRT. He tells us that he understands that he has a drug problem, but then still continues to do what he's doing. We've tried to help him as much as.
Probation officer Ms. Johnson speaks next. She's tried everything: drug treatment, counseling, rehab, but he keeps testing positive. He knows he has a drug problem, but keeps doing it, she says. Even she recommends no bond, and the judge agrees, disappointment written all over her face. Should addiction excuse repeated crimes, or is enough finally enough?
Ultimately, Your Honor, it's up to you, but I don't think a bond is a smart decision.
Yeah, I don't either.
Can I have?
You may. Go ahead.
Can I ask her a question? When did you place him on JCDI? Do you have a date when his term? When was he actually placed in? Was it 2019 when he was placed on probation?
For probation?
Yes.
2019, May 13th.
When did you place him on JCDI? Was it just recently?
Yes, sir. It was in the last.
February of 2025.
Okay, so what changed between 2019, February 25, to say, now you need JCDI?
His drug intake went up. We've tested on multiple occasions. He's tested positive for cocaine on multiple occasions, and we believe outpatient would be the best for him. He had spoken to me briefly as well that he had some issues he wanted to talk through. He had some family issues he wanted to talk through. So we've got him being in front of a counselor, him getting that drug treatment is what he needed. He agreed with us that's what he needed. So he believes that outpatient program is the best option for him.
Did he go to JCDI?
He did. He did test positive on multiple occasions. He drank at one point and he admitted that to us.
So when did he stop going to JCDI, or was he still going at the time of this offense?
He was still going at the time of the offense, but since he picked up a new offense, they had to drop him from that program.
So it was the new offense that dropped.
Barley pleads for another shot. He says he just wants to go back to work, that he's a longshoreman trying to rebuild. But then comes the judge's sharp question. You had a stroke last year, and you're still testing positive for drugs? The courtroom goes silent. Even sympathy turns into disbelief.
And roughly when was that?
March of 2024.
Thank you.
All right, anything else, Mr. Burbank?
Mr. Barley, you've heard what the probation officer said. Did you talk to the probation officer?
Yes, sir.
Speak up so we can hear you.
Yes, sir.
If the court was to allow bond, what is your plan in reference to what you would do when you got out?
As far as my plan, I mentioned to my probation officer, and I believe I mentioned also to you that I would like to get into outpatient program at that rate choice if possible, which will allow me to, I just told you I couldn't work out of the county. The reason why I asked for that was because I'm working at minimum 1,000 hours less than I normally work.
You are a longshoreman, is that
Yes,
correct?
yes, sir, I am a longshoreman.
And the incident in reference to the assault had to deal with your supervisor at the port, is that correct?
Yes, sir, it is.
And so the only ports that you know of are either Houston, Corpus Christi, or Louisiana that
I
you
work
would go to.
at, as far as making my payments and getting back on track, I had a stroke last year.
I'm not worried about your payments.
Yes, ma'am.
You had a stroke last year?
Yes, sir.
And you're still testing positive for drugs after having a stroke.
Yes, ma'am.
Okay. All right.
He talks about family, his mother, sister, kids, even one he's not allowed to see. Then the judge asks, how can you guarantee you'll stay clean? Barley replies softly, my word. But after so many chances, that word means little now. Would you believe him?
Do you have any family?
Yes, I do have
What
family.
family do you have?
My sister, Raquel Barley, also my mother, Raquel Barley, and uncle, Christopher Williams.
And how far away do they live?
Well, as far as my mother and my sister, they live in Houston. As far as a good friend of mine, she lives right there in Port Arthur, in Fraser.
Do you have any kids?
Yes, sir.
Where are they?
I have one in, she's a cheerleading coach at Iowa State University. My son is in, I got two kids here in Beaumont. One that I'm not allowed to see, and then also Tristan, who I just reconnected with Tristan, my 11-year-old.
Mr. Barley, just one last question.
Yes, sir.
How can you guarantee this court, if released, that you wouldn't be taking either alcohol or drugs pending the outcome of this hearing?
Well, for one,
What guarantees?
I would accept that offer of the patch. And I would guarantee, I just want to get back to work. What I do, we only go to work and come home.
You do other things because you've done other things.
Yes, I have.
What's the guarantee that says you're not gonna do those other things when you're doing work and going home?
At this particular time, offer my word, even though the past doesn't.
That's right.
Yes, and that's one opportunity. I see this as my last opportunity to keep everything that I have, and
one of the things is that you tested positive. What date was that, Your Honor?
Barley admits it. Yes, he used alcohol and cocaine. The judge details the night he was found in a car at 3:20 a.m., crack pipe and drugs in hand. It's scary to think you're out there possibly driving like that, she says. This was his 5th hearing. Patience has run out.
There's a date of April, if I may.
Go
April
ahead.
29th, April
Did you
15th.
test positive for alcohol back on that date?
Yes, I did.
And was there a date also of positive for cocaine? Was there?
Yes.
Yeah, there was. So those allegations are true, correct?
Yes, I did.
If the court is not considering a bond and that he needs help, he has pled true, Your Honor, to testing dirty at this point.
Well, he hadn't pled. We're not sworn in, or, I mean, if he wants to plead to the if he wants to plead to the motion, we can take care of that. I mean, with regard to the bond, the allegations, at least for that new offense on May 29th of this year, is that approximately 3 o'clock in the morning, 3:20 in the morning, you were sitting in a running vehicle in an empty parking lot in an area known for prostitution and drug use. You roll down the window to speak to officers. White smoke comes out of the vehicle. You get out. You got crack pipe, allegedly. 4 pieces of crack were found on you, allegedly. My fear is that I don't know whose car you were in, but obviously it's scary to think that you're out possibly driving in the middle of the night, either finding drugs, using drugs in the wrong area after. This is your 5th administrative hearing. So you've already been given 4 opportunities with probation without having come in front of me on an MTRP. They've gone so far above by letting you work out things administratively with ISF, with JCDI, and I approved those things, but they did those things without saying, let's revoke his probation, let's work with them, let's work with them, let's work with them. And then here we are, while you're in supposedly the JCDI program, which is exactly what you say today you're asking for, outpatient treatment program. Based on the underlying offenses and the nature of those offenses, based on the nature of the 2 pending charges against you, I am going to find that setting a bond is not in the best interest in these cases of our community. I am going to leave it at no bond in these cases. We can handle this a couple ways. We can go through the motion. We can get pleas of true or not true. We can set it for a hearing for sentencing. If, depending on what the plea is on the, excuse me, the new charge of possession, we can get with the lab and I can ask them to get that done before that hearing. We can take care of that at that hearing.
Right, I mean, I'm advising not to enter a plea in reference to the new offenses until we know exactly what it is. And the
That's fine.
assault, there may be a question
I
on
think
that.
we can get that taken care of if I make that special request that they get that done in time. Do you want to go through the motion today?
Besides the new offenses, yeah.
Well, I'm going to go through the whole motion. He can enter pleas of true or not true.
Okay.
Mr. Barley, raise your right hand the best you can. Excuse me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, let me get this pulled up a different way. I think I can do it. So, will he waive the formal reading of the motion?
Be well, Your Honor.
The judge's tone softened slightly, but her decision stands firm. She reminds everyone that Barley's bond is revoked. Still, she shows restraint. I'll review the lab results before final sentencing. Even in disappointment, Judge West keeps her balance. Justice with compassion. The courtroom feels heavy, a silence that says it's over.
And that was a 10-year deferred probation for violation of a bond or protective order. And is that correct? And then in cause number 1829063, that's what I need, thanks. Correct. I also have a first amended motion to revoke your unadjudicated probation. It also shows that you were placed on probation May 13th of 2019 for the offense of violating a bond or a protective order, 3rd-degree felony, and that was a 10-year deferred probation. Is that also correct? They, both of these motions allege that you violated your probation. Count one alleges that you committed the new offense of assault April 21st of 2025 in Jefferson County, Texas. And is that true or not true? Count two alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates. And is that true or not true? Count three alleges, in each case, that you failed to provide verification of attending the JCDI program as ordered. Is that true or not true? Well, he was attending, but you were discharged.
Compliant, yes.
So I'm going to put not true to the way that one is worded. Count four alleges that you failed to abstain from the use of any and all intoxicating substances and that you provided a sample that tested positive for alcohol April 15th of 2025. And is that true or not true? Speak up, please. Count five alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true?
Not true.
Count six alleges that you possessed a drug, crack cocaine, May 29th of 2025. Is that true or not true? Count seven alleges that you were at a location other than your residence at approximately 3:19 a.m., May 29th of 2025. And is that true or not true? Did you enter your pleas of true to counts 2, 4, and 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 2, 4, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing, ask probation to do an updated pre-sentence report, ask the state to bring any witnesses with regard to those other cases. We will set it at 11 o'clock probably, but we don't need a bunch of time, do we, on a regular day? We'll just do it at 11 o'clock. And if you need me to call the lab for any reason to make sure that that gets done as quickly as possible so that Mr. Burbank has notice of those results, then just let me know and I'll help take care of that if we can get that expedited. All right, we'll see y'all back at sentencing.
Maybe excuse that.
Yes, sir, thank you.